North Hills. Fort Worth. Okay, there we go. There's Fort Worth. Edinburgh, Beaumont, Brownsville. Have I missed anything? What have I missed? Let's see. Coppell, San Antonio. There we go. Amarillo. Glad to see Amarillo here. Okay, there's some Austin people in the room also. Lubbock. Okay, love it. Y'all make friends. It's fine. This is one of our favorite things about running the virtual clinic is that it really allows us to have people from literally all over the state, which we have now. So we have, let's see, we had El Paso, Lubbock, Amarillo, Houston, Edinburgh. I assume some people closer to McAllen as well, San Antonio. So we just love that. We love being able to put this on for you guys so that everybody can really participate and get a chance to get some insight and some information. So the first thing I'm going to do is just try to share a little video with you guys and hopefully it works. We're going to find out. One hot second.
All right, freshmen, you made the team 3 days ago. Now, I understand the case is pretty long, 234 pages, so how many of you have read the whole thing?
Okay, that's totally fine. How many of you read just half of it?
Have any of you read like a quarter of it?
Okay, raise your hand if you've read any of the case.
Yeah, how much did you read?
I'm on page 4.
Okay, hopefully you guys could hear that. I'm not always sure if you can hear it or not. Okay, Jamie's nodding yes for me. Thanks, Jamie. So we won't be talking about the case specifically today, as always, but we will hopefully be giving y'all some information and insight. You should know that the case was released a couple weeks ago. Hopefully you've at least downloaded it, but really no pressure if you have no idea what you're supposed to be doing with it yet. So we're going to go ahead and get started. So like previous years, I'm just going to run through some of the basic rules, like to refresh so that everybody's on the same page. This year we did update some of the rules. One of the main things we did was we moved all the virtual rules to the very end of the rules PDF. So my advice is just to ignore them unless you find out you're going to have a virtual competition. But we did that just so that they're no longer mixed in for confusion purposes. And then we also updated some rules regarding scoring and how wild card bids for the state competition will be selected. But otherwise, the rules of the competition are the same. What you do when you get there and you're trying your case is all the same. Really shouldn't affect you guys too much. Most of the rules changes really affect the people running the competition. So as far as team competition goes, each team, you can have minimum of 6 people up to 10 people in, each competition. You have attorneys, witnesses, and a timekeeper. So 3 attorneys, 3 witnesses, 1 timekeeper. We really do recommend trying to get a timekeeper if you can. It will help your team a lot if you have a timekeeper who can consistently keep time for you. You also will get a roster sheet. Please fill it out entirely correctly. Please type if you can. That makes it very easy. One of the reasons we do that is because most competitions does that help? I can't see the chat, so I have no idea if it's working or not, if that is what you wanted.
That's better.
Okay, thank you. So I apologize for that. But basically any 6 of the team members can compete in each round. Again, it helps us to know your names correctly. Most competitions award best advocate and best witness. So if we don't know your name, we don't know who did which role, we don't know which team member portrayed which witness, you may miss out on some votes if we just can't figure that out. Team duties generally, So we have 3 attorneys. One will give an opening and one will give a closing, and they do have to be 2 different people on your team, 2 different attorneys. Each attorney will do a direct and each attorney will do a cross. And then you have 3 different witnesses. And so it is actually a rules violation if you don't have different people doing each of those jobs. And so you want to make sure that you have your 3 attorneys so that you can actually compete on the day of your regional competitions and particularly when you get to state as well. And then the attorney who examines a specific witness, meaning the attorney questioning a witness, is the only person who can make an objection during that witness. So I'm kind of going through this a little quickly because I'm pulling these straight from the competition rules. So if you have questions, like please, first read the rules. If you need clarification, ask your regional coordinators. You can always have your coach send an email to Melissa Garcia to get a clarification. And then when we get to the end of this, if you have any questions about the rules, like feel free to ask and we can try to get some answers for you. See. As I mentioned, student timekeepers. It's very helpful for each team to have a timekeeper. If you don't have a timekeeper, you're stuck with whatever time the other side is giving. So you wouldn't have any opportunity to say they're not keeping time correctly, they're not pausing it correctly during objections, anything of that nature. So even if you just like have a friend who doesn't want to be part of mock trial, but they're really good with a stopwatch, getting them to come just keep time for you. They don't have to read the case, they don't have to know anything about objections. All they have to know is how to keep the time correctly. So that could be an option for somebody who wants to participate but doesn't feel comfortable maybe with public speaking. So we do highly recommend that you have a timekeeper. Let's see. And if you have questions at any point while I'm doing this, you can put them in chat. Jamie or Stacy or Kevin can interrupt me and ask questions or get clarification for you if they feel like, it's a good time to do that. Okay, so just some basic rules and formatting. So the problem consists of 3 witnesses per side. All of them have names that should be gender neutral, meaning any team participant can present as any of the witnesses. All 3 witnesses have to be called. If you choose not to call a witness, you get 0 points, both for the witness and for the direct. And that's, you don't really want to do things that are going to lead to you to get 0 points, is my personal advice. You may not call any of your witnesses as a hostile witness, which means that you can't lead them or cross-examine them in any kind of way. And some of this, if you are a beginner, yes, it should be recorded, Tim. I believe we were recording. I have an
Yes,
indicator that
yes.
I've recorded. Yes, Yuri's recording also. Okay, great. So yes, this is going to be uploaded just like the previous years are uploaded as well. If you want to come back and look at this later, you can definitely do that. So the problem is 3 witnesses per side. You can't call them a hostile witness. And again, you have 3 attorneys. Each attorney has their own witness that they would call, and they are completely responsible for that witness. The sequence and time limits, we start out with opening statements. You have up to 5 minutes. You don't have to use the entire 5 minutes, though if you choose to only use 20 seconds, I would consider whether or not you're, effectively presenting an opening statement. That would get you a lot of points. Direct and redirect, you get 25 minutes. So when the plaintiff is presenting their case in chief, they would have 25 minutes to put on all of their witnesses, and the defense would have 20 minutes for all of their cross-examination and recross questions. And then you would have 5 minutes for your closing argument. You can reserve up to 1 minute for a rebuttal if you are the plaintiff. You don't have to use up your entire time. for, you know, direct, redirect, cross, recross portions, those very frequently, you know, you might see like 20 out of 25 minutes being used for direct and redirect. But maybe on cross and recross, you're using the full 20. It's like, it's up to you and what questions you feel like you need to ask. Sometimes it goes a little bit quicker if there's not a lot of objections. And so, you know, we as judges don't typically look at like, okay, how much time did you use for those two portions of it, versus like opening and closing. If you're not using very much of your time for that, that might get you a much lower score because you've lost the opportunity to make arguments to the judges who are giving you scores. So the time is for all of the witnesses combined, not per witness. Otherwise, this would be like a 6-hour trial. So from the time you call your first witness on direct when you end, it'll take, you know, generally, I would say each side's case in chief takes about 45 minutes to an hour, just depending on like, how, again, how many objections there are, whether there's any kind of conversation that has to happen. But, you know, basically you call your witness, let's say there's no objections, you would call your witness, and from the time you've called them to the end of your first direct, maybe that's 5 minutes. Okay, great. And then your redirect is another 1 minute. So now you have 19 minutes left for your other two witnesses, essentially, is how that would work. And time does stop when objections are made. And so that's frequently where some of the time stuff goes off the rails, is if that's not being done correctly. But generally speaking, this is the format. Neither side can alter the trial sequence at any time, which just means that the plaintiffs can't go like, oh, we want to go second. It doesn't work. The plaintiff has to go first, has to call all three witnesses, and then the defense goes and calls all three of their witnesses. I mentioned redirect and recross. You get one of each, no more than that. Some regional competitions don't always very closely follow that rule, but the ones that the Dallas Bar runs, and particularly the state competition, we're pretty strict on that, just because if we did more than that, you guys could always come up with more questions because y'all are brilliant. And so it's just a way for us to really limit the time that we're allocating to each trial. As far as independent research goes, you can independently research whatever you want. That's totally fine. If you need to better understand rules of evidence, or you kind of want to understand, for just a random hypothetical, like why a submarine may sink in the middle of a cab, you know, whatever it's called, a river, a lake, I'm not even sure. You know, you could do that, but that information does not come in. The only thing that the witnesses can testify to is what is in their fact statement. But if you need to do a little bit more research so that you better understand the terms your witness is using, or just so you feel more confident, that is totally fine. So like, feel free to watch YouTube videos or read articles to try to understand like the rules about hearsay. We attorneys do that all the time. Sometimes we have to go back and research and figure that out. But you don't get to cite to that research or any of the cases you may have looked at as part of objections or responses. You don't get to use that as part of a witness presentation, anything of that nature. And if your independent research suggests that a fact in the case is incorrect or inaccurate, the case still controls. So an example would be, you know, if the case says the sky was pink, but your research says the sky can never be pink, you know, nobody can testify, like, scientifically speaking, pink is not a color that the sky can be. You're kind of bound by the witness statements and what the witnesses testify to regarding the color of the sky. Trial communication. Again, these are all screenshots directly from the rules. So this is not me just like typing extra things in here you need to learn. The main thing about this is like, we can actually see when you're communicating with each other. So the only people who can communicate are the team seated, you know, in front of the bar. So the three attorneys and the three witnesses. You cannot talk to the timekeeper at all. The only communication with a timekeeper is you can ask the judge for a time check, and then the judge can ask the timekeepers, you know, how much time is remaining. Otherwise, just the three attorneys and the three witnesses. You cannot talk to your coach. You cannot talk to any teachers. You can't talk to mom or dad who may be in the back. And again, we can see a lot more from the bench than you think we can. And so again, we don't allow electronic devices, unless there's somebody approved to use an electronic device based on a disability accommodation, but that needs to be taken up with the regional coordinator before trials start. That's not something that you would just like roll into a courtroom and talk about. And then again, so it doesn't really matter like where you necessarily have to sit. I said like in front of the bar, but I understand like some courtrooms are really small and maybe you only have room for your attorneys. So what we would request in that case is that like the witnesses sit on the very first bench and that there's kind of a gap between the witnesses and everybody else so that the judges can see like who is participating in the round and who is not. So it means like you really only the participants can talk to each other. Okay, and then if there's any questions, you can always take that up with your presiding judge. Like, hey, there's not enough room. We just want to provide some clarity. Like, these are the people who are participating. These are the people who are not. Because you don't want to get hit with like a rules violation if there wasn't actually a rules violation. Okay. Objections. There's lots of objections you can make. The one thing that I really wanted to point out was just that this rule lists some objections that can be made. It does not list all objections that can be made. So go look at the competition's rules of evidence so that you can figure out all the objections. I just don't want you to feel like you're limited to only what this rule 4.19 says, because there are more objections that can actually be made. And then I know in the beginner breakout, we do plan to kind of give you a little bit of an introduction onto how to introduce exhibits. I recommend looking at rule 4.20. I think it's 0.1 and 0.2 unless I change those numbers somehow this year. They give a breakdown on like how to actually introduce exhibits into evidence. But again, we're going to go over that at least in the beginner one, but that's also something that you can feel free to like go find YouTube videos, go do some research, figure out how to do that. That can be really helpful as well to know how to do that correctly. Okay, so the number one question we've gotten every year at virtual competition is, what is the dress code? So these are the same pictures I used last year. I do apologize. I did not have time to go pull pictures from our most recent state competition. So the rule about dress code is that there actually is no rule about dress code. But we do expect participants to be, nicely dressed, clean, presentable looking. That does not mean every single person has to wear a suit. We understand that like not everybody can afford a suit. Maybe a suit's not available in your size. So generally as nice as possible, nice slacks or skirts or dresses, a nice top. You don't have to wear a jacket. There are no rules regarding point deductions. The only rules really regarding wearing costumes or wearing anything that would identify your school, such as a letter jacket or a school shirt or something of that nature. So female presenting students are welcome to wear pants. They are not required to wear a skirt or dress. And if you do choose to wear a skirt or dress, there is absolutely no expectation or requirement that you wear pantyhose. I feel compelled as a female individual to present that information to you guys every year because we always have some anxiety around that question. And so we try to make sure y'all know like absolutely not required, not an issue. And then at your competition, if you do feel like a judge is scoring you based on how you're dressed, that's something to take up with your coordinators, at that time. But generally speaking, we instruct judges, at least in the Dallas area, we're not taking into account what they're wearing. We're taking into account how you present. So I have some pictures. all of these pictures, every single student participating is wearing, acceptable dress. And so you'll see that there's a variety of colors, there's a variety of outfits, especially for the ladies. There's different ways of wearing different items. Some people wear jackets, some people don't. Some guys wear ties, some don't. And so we just put these pictures together just so you guys can see and understand that, like, we're not that concerned. So this particular team, their attorneys all had matching ties, super cute, not required. But you'll also see that their suits don't match, which is also fine. You'll see that the female presenting student, she's not wearing dark pants. She's wearing super cute pants, totally acceptable, totally allowed. She looks completely presentable, and that's really all we care about. Here's another picture. You can see some of the students are not wearing jackets. Some of the students are not wearing ties. Again, absolutely nothing wrong with any of these outfits. And so you can see some teams coordinate better than other teams. Again, like, that's just not something that we factor into the scoring. Everybody in all these pictures looks great. And so, I go through that again just so that there's nobody sitting there worrying about, what they're wearing. I've actually never had a real issue with the way anybody has ever dressed at any of the competitions that I've attended or presided over personally, though other judges may have different experiences.
And I'm just gonna jump in for a second. We
Yeah.
had a question in the chat. Does it matter the color of our outfits? The color of your outfits don't matter at all. Like, we've seen every color of the rainbow. And in the pictures that you saw, there's a lot of dark colors, light colors. I think a pop of color is great, whether it's a tie or a top or something like that. But yeah, it definitely doesn't matter the color of your outfit. It's fine.
Yeah, if you have a beautiful purple suit, rock it. Like,
Yeah.
I am all here for it. Unlike law school mock trial competitions where they get very strict into like what you're wearing and all of that, you guys are high schoolers, like, we want you to express yourselves. So as long as you're presentable, are females required to have hair pinned back, or wear your hair how you want to wear your hair. Yeah, again, be yourselves. We love to see some style. We love to see some personality. As long as, I think the general rule of thumb I would give is, like, don't wear something like if you're trying to go to a club, but otherwise you're probably going to be fine. Avoid jeans if you can, but if all you have are jeans and they're like very dark wash, nice looking ones, that's fine. I almost never even really pay attention to what the students are wearing personally. Jamie, I don't know if you have a different perspective.
No, I really don't think what you're wearing matters as long as, like Jessica said, you're presentable. And the one thing I'll add to that is that you're comfortable. So the one thing I have seen a few times and that I have done a few times myself when I've gone to court is wear new heels that I haven't broken in yet. And that means that the entire time I'm sitting in court, all I'm thinking about is how much my feet hurt. So I would tell people that it's not the time to test out new shoes. And if you're wearing really high heels, but you're not that experienced in walking in high heels, then maybe save those for another time.
Yeah, that's a great tip. And I've also worn like a brand new jacket that I wasn't used to wearing. So like the whole time I felt like I was like moving my shoulders, trying to get used to how it fit my shoulders. So whatever you wear, try to wear it in advance of your competition day so that you can get comfortable with it and you're not like fidgeting on the day of, because that kind of stuff will be distracting. And that kind of flows into trial etiquette as well. You don't want to be doing things that distract the judges from your arguments, right? So I don't really have extra slides for this one, but the main thing is you want to treat the presiding judge as if they're really a judge. Their rulings go, make sure that you're making legal arguments, but not like arguing with the judge. Like, that's not fair. I don't like that. You don't get scored based on if your objections are sustained or overruled, because quite frankly, some of your presiding judges will like intentionally rule incorrectly just to see how you respond sometimes. So remember that you want to make the best objection you can, make the best legal argument when you have the opportunity. But once the judge has ruled, it's like, thank you, may I proceed with my questions? Were there some other questions about dress code? Hold on. What type of shoes do we prefer females to wear? We don't have a preference and do not care. I wear flats to court. I'm not here to show off my, shoe fashion when I go to court. As long as they're generally closed-toed, you're going to be fine with your shoes. Can witnesses dress their character? No, because that would come into like a costume. I don't know, Jamie, Jamie, Kevin, if y'all have any feedback about that question.
No, that's right. We would ask that witnesses dress the same way you would if you're one of the attorneys. And you can use an accent when you get on the stand. You can really become your character, but not in terms of physically how you dress.
Yeah, and I will say that's going to mirror like real life witnesses as well. Most people, when they go to court, dress as nicely as they can. I mean, sometimes you see people making no effort, but for the most part, the ones who want to be taken seriously, they dress presentably, they dress nicely, something that, looks business casual, maybe a little bit more professional. The only people who really wear anything when they come to court are police officers. But even detectives usually just wear suits. So otherwise, like, if you're trying to dress like a hippie, then you're kind of getting a little bit too close to maybe wearing a costume. But if your witness is just wearing bright colors, totally acceptable. That kind of thing. So, back to trial etiquette, reminder to witnesses that when an objection is made, you want to stop talking, and then you're going to continue talking once you're instructed to do so, or once the attorney has asked you another question. I, at state 2 years ago, had to admonish a witness, not state, I think it was one of the regional competitions. I had to admonish a witness to stop talking or arguing during objections. You're going to lose points for that as a witness because that's just a no-no as far as trial etiquette goes. Your job is to be a witness, not to be an attorney, not to argue objections. Okay. And so we're going to watch a video in a second, and it's going to go through, you're going to see a little bit of an opening, some directs, some crosses, that kind of stuff. And then that way, you'll get an idea of kind of how to present yourself to the court, and have an idea of kind of what it looks like once you're there. Okay. So we're gonna cross our fingers that the video works. Before we start the video, I do want to give you guys a chance to ask any questions, any burning questions you have from what I have presented, what I have talked about so far. And if you don't have any questions, that's totally fine. Have any rules changed for the artist? No, but thank you for reminding me. The one thing that came up at state last year for the courtroom artist competition is we realized that not every region sent the correct number of artists, by which I mean, if your region qualifies 3 teams to state, that means you also qualify 3 artists to state. So if you're an artist, if you know your team's going to have an artist, stay on top of that on behalf of your artist to make sure that, like, if you're the second qualified, it doesn't necessarily, they're scored differently. So just because teams A, B, and C qualify to state doesn't mean artists A, B, and C qualify. It could be A, C, and F, right? But for however many teams go to state, that number of artists also get to go to state. And so we had a couple of regions where the artists didn't know that, so they just didn't show up at state. So they missed out on the opportunity to compete at the state competition, because it just really wasn't communicated that they had qualified. So, but no, otherwise the rules have not changed for artists. That's a great question. Thank you so much. Are there any other questions before we watch the video? So to recap, your attire just has to be professional, but you're able to dress up in makeup, hair, etc. Of course, you know, again, if you're comfortable wearing makeup, wear it. If you don't like wearing makeup, you don't have to wear it. Absolutely no one's going to judge you because you don't have your mascara on or anything like that. And so again, comfort over, you know, other things is my recommendation. Jamie, I'm gonna let you answer a question. How is the witness supposed to react when they're getting crossed?
Well, it really depends on the witness and it depends on the person playing the witness. You can be completely straightforward and straight faced and just answer the questions as asked. If you think it's part of your character to get a little heated, to have a little bit of a temper on cross examination, then feel free to do that. If you are playing kind of a wacky witness and you want to carry that over into cross examination, that's fine too. So it's a wishy-washy answer. But yeah, I mean, it really just depends on the witness and how you want to play the witness. And that is one thing that judges are looking at is if you portray a character in your witness on direct examination, then you want to make sure that you don't fall out of that character on cross examination. You should be consistent the whole time.
That's a great answer. If the case involves an astronaut, can he come in costume? Absolutely not. That's again, it's against the rules to wear a costume. That's one of the few, again, in general, we don't care about what you wear, except you are not allowed to wear a costume. Let's see. Will you please briefly explain when more than one team would qualify for state? So there's two circumstances where more than one team qualifies. The first is we have what are called automatic qualifications. So if you have less than 10 teams competing, your region qualifies one. If you hit the 10 team number, then you get a second qualification for state. If you hit the 20 team number, which we only have really, I think maybe two regions that hit that number every year, but Melissa's not here to double check me on that. But if you hit 20, you'd get three teams that automatically qualify for state. And then the other way is then we do wild card draws to kind of round up to an even number that is suitable for like a nice breakdown of competition. And so some years we may have two wild cards. I think one year we had 5 wild cards. It just depends on the year and how many automatic qualifiers we get from the regional competitions. So there are some regions where there is exactly one team competing and they automatically qualify to state. But their region also would not get a wild card, if that makes sense.
Hey Jessica, I saw a question about accents in the chat.
Mhm.
So here's the thing about accents. If you want to do an accent, great. If you don't want to do an accent, great. But from having experience in judging some of these trials with witnesses who do accents, if the accent changes throughout the trial, the judges notice that. Take that information with what you will.
Yeah, and if your accent's not very good and you can't do it consistently, it can just be distracting and it can distract away from like how well you're actually answering questions. Like that's ultimately how, you know, witnesses, their score is based on like how well did they answer questions, how well did they hold up and cross, and like do you believe that they're the person that they're portraying? And so sometimes the accent can be a hindrance more than a help, is what I would say. But I've also seen some brilliant accents where I'm like, oh, yes, I definitely believe this person may be French. So yeah, I think what Kevin says is like, make sure you're committed to it is probably a good answer. Does characterization affect the score of the witness? I'm not sure I understand the question, but Kevin or Jamie or Stacy, if y'all understand the question.
I'm with you, Jessica. I would need
Maybe,
clarification.
can you maybe clarify your question? I don't want to butcher your name. Ife? Um, let's see, how many people in a group can be qualified for state? Again, I'm not really sure what your question is, Sheetal, but generally, like if your team qualifies for state, your team qualifies for state. It's up to you guys as to how many you're bringing with you. But again, you're going to be stuck with like only 10 people can be on the roster, only 3 attorneys, only 3 witnesses. And so how you guys choose to allot that is, you know, up to you guys. But how much does the personality of the witness affect the score? It can affect the score. So if you have somebody who just, I don't know, Jamie, have you ever had a time where like the personality of the witness has affected your score? I know it can affect it positively, like if you're very good personality.
Yeah, I think that's right. I don't think I've ever had a situation where I've been so put off by the character or the personality that the witness is portraying that I take points off. Like, that's not a thing. The one place I will say that sometimes it comes into play is when I'm picking the best witness for a round. Then sometimes if I see someone is just really outstanding at portraying the witness and the character that they're doing, and they're really consistent, then that might come into play when I'm choosing best witness. But for actual scoring, it's much more about the answering of the questions.
Right. Do all members in your group have to qualify for state? It's a team competition. Your team qualifies or doesn't qualify. So there's no, other than the courtroom artist competition, which is an individual competition, the team qualifies or does not qualify. So there's no like your best witness gets to go or anything like that. It's kind of an all for one kind of deal. So it's either your whole team or nobody on the team. And then the artists again are scored separately and qualify separately from the teams. Those are some great questions. You know, each of the breakout rooms, we're going to have an opportunity for you guys to ask some questions in as well. And so I do want to give y'all a chance to watch some of this video. And so what we'll do is I'll play the video and then, you know, we'll open the breakout rooms and let people start selecting. And then once kind of everybody's in a breakout room, then our breakout rooms will get started, if that makes sense. So here we go. And then just holler at me in chat if it's not working for some reason.
May I proceed?
You may.
May it please the court, members of the jury, and Miss Hasham. Riley Truman had a secret about his family that haunted him. As an elected member of the school board, Riley was terrified that his secret would get out. So he tried to cover it up. The members of the jury today are going to learn that Riley, well, he had a problem. This is Scout Cumberland. You're going to learn that Mrs. Cumberland, well, she knew Riley's secret and she kept digging it up. And on December 2nd, Mrs. Cumberland brought up Riley's secret at a school board meeting. Furious and terrified and drunk, Riley tried to stab Mrs. Cumberland. Mrs. Cumberland saw Riley step towards her and saw his hand go towards his knife, so she panicked. Mrs. Cumberland, well, she saw his knife, so she saved her life. Because Mrs. Cumberland saved her life, that's why she's arguing self-defense. Today you'll hear that Mrs. Cumberland, while she reasonably believed Riley would harm her, so she reasonably saved herself. Now, Mrs. Shawn got up here and told you that Mrs. Cumberland acted with the intent to kill Riley Truman. But Mrs. Shawn didn't bring up one very important fact that means that the prosecution will not be able to meet their burden. Riley Truman had a knife. Now, when the prosecution charges someone of a crime, they carry a burden. Today, they had to prove both elements of first-degree murder beyond a reasonable doubt. The highest burden in our legal system. Now, the defense, we concede the first element. Mrs. Cumberland killed Riley Truman. But the prosecution won't be able to meet their second element. And Mrs. Cumberland acted with the intent to kill Riley Truman for 2 reasons. First, Riley attacked first. Second, Mrs. Cumberland reasonably believed she had to save herself. Starting with the first, Riley's attack. Today you're going to hear from a member of the school board, Dr. Goodman. She was going to tell you that at the December 2nd school board meeting, Mrs. Cumberland brought up Riley's secret. Immediately after, Riley grabbed Mrs. Cumberland. And you'll hear from another member of the school board, prosecution's own witness, who will tell you that they saw Riley step towards Mrs. Cumberland. They saw them lean towards Mrs. Cumberland directly before they were shot. Riley attacked first. And because of this attack, Mrs. Cumberland reasonably believed she had to save herself. Now, Mrs. Cumberland, she is going to get up in this witness stand today, and she's going to tell you she was terrified. She'd seen Riley draw his knife before and seen him do it very quickly. So when she saw Riley step towards her, saw his hand go towards his knife, she panicked. And you're going to learn that the science, well, it also aligns with Mrs. Cumberland. You're going to hear from forensic pathologist Dr. Frankie Rose. She's going to tell you that the angle of the bullet in Riley's body is consistent with Riley's left side, the side with the knife lunging towards Mrs. Cumberland. When the prosecution charges someone of a crime, they have to prove that their version of events is the only reasonable one. Members of the jury, Riley Truman had a secret. He had a knife to keep it that way. When Mrs. Cumberland saw this knife, she saw Riley step towards her.
Can you please introduce yourself to the jury?
Good evening. My name is Alex Rayburn.
And what is your profession?
I'm a detective for the Little Rock Police Department.
How long have you been with the police department?
For about 20 years now.
And can you please tell us some of your history with this department?
Well, I started off as a beat cop, worked my way up to detective, and was then promoted to lead homicide detective.
And what are your duties as lead homicide detective?
Well, I run investigations into suspicious deaths around Little Rock. That may include collecting evidence, interviewing witnesses, and analyzing ballistics and autopsy reports from our crime lab to determine if foul play was involved, and if so, who was responsible.
And did you investigate the death of Mr. Riley Truman?
I did.
How did you first become involved in that case?
On the evening of December 2nd, 2021, we received reports of a shooting during an official meeting of the Little Rock School Board. I arrived on scene at approximately 8:06 p.m. to investigate.
And what was your first step?
The EMTs on scene directed me toward the body. I identified the victim as Riley Truman.
And, Your Honor, permission to approach the witness with what has been marked as Exhibit 6.
Granted.
All right, Detective, I'm handing you a copy of Exhibit 6. Can you please identify it for the jury?
Yes, this is a short-form copy, a copy of the short-form autopsy report generated by the medical examiner's office. We work with these all the time.
And was it generated during regular police business?
It was?
And was it generated at or near the time by someone with knowledge?
Yes.
Your Honor, the prosecution now offers Exhibit 6 into evidence. Its authenticity has been stipulated.
No objection pursuant to 8036.
Received.
Would you agree that you wish you had studied that knife more?
I wish I could have studied all of the things I've worked on more.
All the things, but just this unsheathed knife specifically, you wish you'd studied that more.
That is included, yes.
And you've made a mistake with the homicide in the recent past, haven't you?
One time, yes.
And to clarify, that was 4 months before this investigation, and an investigation about a homicide with a knife, correct?
That's right.
In that investigation, you missed a key piece of evidence, right?
I did.
That evidence, it indicated self-defense, didn't it?
That evidence did indicate that.
And in that case, the charges against the suspect were dropped when that evidence was found.
That's true in that case.
And you were made aware of this mistake before the December 2nd investigation, correct?
That's true.
Now, I'd like to keep talking about your investigation. On December 2nd, you didn't make any arrests. I have that right?
I did not arrest anyone, that's correct.
Proceed.
You may.
Please state your name for the court.
My name is Charlie Goodman.
Tell us a bit about yourself.
Well, first and foremost, I'm a mom. I have 3 rowdy, immature boys, my 2 twins, and my husband. It's not easy being the only girl in the house, so I try to keep myself busy. I'm a doctor, and I also serve on the Little Rock School Board.
Tell us some more about your work.
Sure thing. I am a specialized pediatric surgeon. I work with newborn babies and those who haven't quite popped out yet. It definitely can be stressful, but it is some of the work I am the most proud of. That and my work on the Little Rock School Board.
What do you do on the school board?
I mainly help our school district on any leadership decisions. I serve with Mrs. Weston and Mrs. Cumberland.
How did you meet Mrs. Cumberland?
I first met her when we had some open seats to fill on the board. I thought she would be a great fit for Little Rock because of her education-based company, so we really wanted to try and wrangle her over here in a meeting with some potential candidates.
For the school board, your reputation is important to you, isn't it?
Of course.
You need a good reputation in the community to get reelected.
I like to think I have a good reputation with the community because of all the work I do helping all the children, but yes.
Well, my question was a little bit more specific, Dr. Goodman. I didn't ask you if you think you have a good reputation. I asked you if you need a good reputation to get reelected. You do, don't
Sure.
Now, you supported the defendant for a position on the school board, didn't you?
Yes, my kids even drew little signs for her to carry at her campaign rallies.
Yeah, so you helped her make signs and stickers.
Yes.
You even spoke at one of her rallies.
Yep.
You loaned her $5,000.
Yes, but not to toot my own horn, I am a highly specialized surgeon in a niche field, so I could stand to loan a friend some money.
So you did loan her $5,000.
Yes.
So it's safe to say that at this point you were publicly supporting the defendant.
Yes, I thought we both had very similar ideals on how to help the children of Little Rock.
So that was a yes to my question.
Yes.
Your Honor, members of the jury, on December 2nd, 2021, Scout Cumberland murdered Riley Truman. It wasn't an accident, it wasn't a mistake, and it wasn't self-defense. The truth is, it was intentional, it was purposeful, and it was exactly what the defendant wanted to happen. How do we know this is the truth? Because the defendant's words and actions, beyond any reasonable doubt, reveal it. They reveal her intentions, and they reveal the lies she's telling us in order to get away with murder. Let's look at what we know. You heard from Drew Arden that the defendant was furious with Mr. Truman after she lost her diamond, and that she promised to personally make sure that Mr. Truman got what was coming to him. And that was before she found out that Mr. Truman's grandmother had bought the diamond. We know that the defendant blames Mr. Truman for wrecking her finances, destroying their company, ruining the school board, and betraying their friendship. The defendant admitted that she chose to bring a loaded gun into a board meeting, chose to provoke Mr. Truman out of the blue, chose to follow him into a hallway and broach his family's history, chose to draw her weapon, and chose to fire twice. We know from Miss Weston that the defendant stood over Mr. Truman's body as he bled out and declared that Riley finally got what was coming to him. Good riddance. To escape these damning the truths, the defendant, much like the jewelers she learned about from Miss Weston, has claimed that the killing was justified. But how did the defense try to prove this? Well, they paid Dr. Rose $10,000 for her testimony, and all they got for that money was that Mr. Truman's left foot might have been in front of his right foot when he was shot. They called Dr. Goodman, who spent half her testimony talking about chocolate milk, because she didn't see the shooting. The defendant, well, you got to judge the defendant's credibility for yourselves. Now, to be fair, the defendant did testify that Mr. Truman reached for his knife. But the truth is, it doesn't matter. And it doesn't matter because the one lie that the defendant needs you to believe isn't that Mr. Truman reached for his knife. The lie, members of the jury, is that the defendant is afraid. Recall what Miss Weston told you, how on November 18th, Mr. Truman embarrassed the defendant in front of teachers that she'd invited to a board meeting. Well, in the parking lot afterwards, the defendant learned that she could provoke Mr. Truman into reaching for his knife by broaching his family's racist history.
May it please the court, Mr. Rahane, members of the jury. As an elected official, Riley Truman was desperate to hide his family's racist past. Mrs. Cumberland exposed him. When she brought up his secret at a public school board meeting, Riley snapped and tried to stab her. She saw his knife, so she saved her life. Because Mrs. Cumberland had to save her life, that's why she's arguing self-defense today. The evidence has shown she reasonably believed Riley would harm her, so she reasonably defended herself. Now, the prosecution is charging Mrs. Cumberland with first-degree murder. In doing so, they hold a burden. They had the burden to prove both elements of first-degree murder beyond a reasonable doubt. That's the highest burden in our legal system. We don't dispute the first element. Mrs. Cumberland killed Riley Truman, but the state has failed to prove the second, that she acted with intention to cause his death. They failed because of two simple facts. One, Riley attacked first, and two, Mrs. Cumberland reasonably believed she had to save herself. Let's start with that attack. When Mrs. Cumberland brought up his darkest secret in public, Riley
Okay, so I know that cut off a little weirdly there. Isn't it? No, that was there. There's actually two different female attorneys on that team to answer the question that just came through. We just clipped parts of the video just to give you an idea of what it looked like, but I didn't want to, sit here and make you watch like 2 hours of a video. That is, I believe, the high school national championship round from last year. And so you can go on YouTube, watch the whole thing to get an idea of what some excellent teams do, their strategies, all of that. Are those attorneys available for hire? I don't believe they're licensed attorneys yet, so I'm going to say no. So are there any? There were some questions that came through in chat while we were watching the video. If anybody has any questions, any lingering questions you want to ask, you can do that right now. The last thing I wanted to say was our mock trial YouTube page has the videos we've made in the past years. It also has our past state final rounds. And it also has a judges panel that I believe Jamie participated in, but they just did like a roundtable discussion from some presiding judges who judged a bunch of rounds with things that they like, things that they don't, tips for teams, that kind of stuff. I highly recommend going and finding it. What is the YouTube name? It is, let me see if I can just grab you guys a link really quick. Nope, that's not YouTube. Let's see, Texas High School mock trial. I meant to actually put it in and I forgot to do that for you guys. Apologize. There is the link to the YouTube page. The national competition does get a different case problem, yes. So last year was a criminal trial, I believe. So that's what we just watched, was a criminal trial. I'm just not completely certain that was last year's video. But yes, they have a different case problem. And so the problems that we present in Texas are different every year. You're not going to be able to find it online. You're not going to be able to find examples of it online. And we don't allow recording of rounds, generally speaking, until we get to like the state finals. So our recommendation is to watch past competitions and pick up on techniques and tips and tricks from those things. Okay. If there's no other questions at this time, I'm gonna let everybody, Beery, I don't know if you want to explain. I think once she opens the room, you can select your breakout room. Is that
Yes, they'll be able to move themselves into the room. Yes.
perfect?
I went ahead and opened them now. So.
Okay, perfect. The rooms are open, so you guys can just self-select between beginner or intermediate and advanced. If you pick one and then you decide you want to change, you can come back out here to the waiting room and Beery can reassign you if it's not working for you to reassign yourself for some reason. And then Jamie, Stacy, Kevin, I think I have 10:01. Maybe we can start like 10:06.
Yep, sounds good.
Sounds good.
Rush by 10:10 though, I would say.
By 10:10 at the latest, you will be late, according to Judge Olin. So, take a break, grab some water, go to the bathroom, all of that. Pick your room. We'll see you guys soon.